Ready, start. This court has repeatedly reiterated that if the circumstances proved are consistent either with innocence or guilt, the accused is entitled to the benefit of doubt, and that where two views are possible, the one favorable to the accused must be adopted. Tested against these principles, in the present case, the evidence on record can in no fathomable circumstance complete the chain of circumstances pointing to the guilt of the accused persons. The prosecution case reveals substantial gaps. The first and most glaring circumstance is the omission of the names of Najim and Aftab in the FIR. PW1, the complainant and the father of the deceased, expressly named six persons with whom he admittedly had long standing enmity, yet he did not attribute any role to the present appellants Najim and Aftab. This court in Ram Kumar Pandey versus State of Madhya Pradesh has emphasized that when important facts are omitted in the FIR, such omissions are relevant under Section 11 of the Indian Evidence Act 1872 in judging the veracity of the prosecution case. In the present case, both PW1 and PW2 were admittedly familiar with Najim and Aftab. Despite this, their names were not mentioned in the FIR, nor was any contemporaneous explanation offered for their absence. The High Court acknowledged the omission but brushed it aside as inconsequential. This approach is untenable. In a case based solely on circumstantial evidence, every circumstance must withstand rigorous scrutiny. The failure to name two of the three appellants in the FIR, despite the complainant's familiarity with them, casts a serious shadow on the subsequent attempt to implicate them. It raises a legitimate inference that their names were introduced at a later stage, thereby suggesting the possibility of false implication. If PW1 and PW2 genuinely believed that Najim and Aftab were responsible, there is no plausible reason for their omission in the impugned FIR. This significant omission strikes at the root of the prosecution narrative, undermines its credibility, and constitutes a material fact that must weigh heavily in favor of the accused. Even when the boy went missing the next day, he maintained silence, and when the body was found on 6/6/2007, he still did not disclose this alleged conspiracy. Significantly, on that very morning, he scribed the FIR at the dictation of PW1, yet he omitted this crucial fact. His explanation that he did not take the conversation seriously because of pre-existing enmity between Wahid Ali and Nanhe Khan's families, and therefore assumed it was double inverted comma loose talk double inverted comma close, is unconvincing. If indeed he had overheard an open and categorical threat to commit murder, it is inexplicable that he suppressed it from the complainant, from the police, and even from the FIR that he himself scribed. Furthermore, PW2's testimony that he overheard such a grave conspiracy being discussed in a marriage feast with several villagers and guests present appears inherently improbable and lacks plausibility. Conspiracies to commit homicide are rarely, if ever, hatched so loudly and publicly as to be overheard by passers by.